Welcome to The Change Up with Vincent McCrudden, bringing crucial civil liberty and justice system topics into focus to promote change. And now your host, Vincent McCrudden.
Hello, welcome to my podcast, The Change Up. I'm your host, Vincent McCrudden. First, I would like to thank all of you who listened to last month's podcast on free speech and censorship with Professor Nadine Strassen and Anthony Alonis. Actually, a few days after that podcast, the Senate called upon the CEOs of Twitter, Facebook, and Google and talked to them about censorship. That topic is going to be an interesting topic in the years to come, and I urge all of you who didn't listen to that podcast to download and listen to it. Today, our topic is going to be probably one of the most critical topics that I will ever cover. It is on the power of prosecutors and regulators and the idea of selective prosecution. In all the articles, cases, and research papers that I have read over the years, it is probably the role and power of the prosecutor as one of the leading reasons for the largest incarceration rate in the history of mankind, anti-competition, and wealth disparity. I'm really honored and proud to have as my guest Mr. Caleb Kruckenberg. Caleb is a litigation attorney with New Civil Liberties Alliance. He brings vast experience on both sides of the aisle, both as a prosecuting attorney, a criminal defense attorney, a public defender in both district and appellate courts. Welcome to the podcast, Caleb. It's great to have you on.
Thank you very much. It's good to be here.
So first, Caleb, we have a lot to attack today, but maybe you can first explain to the audience a little about what your organization is, the New Civil Liberty Alliance, and exactly what role you play there.
Sure. So I'm litigation counsel at the New Civil Liberties Alliance, and we're a nonprofit, nonpartisan litigation organization that was founded really to push back on administrative overreach. And, we deal with a lot of different areas, but my focus is on when administrative agencies and regulators, and particularly, they overstep their authority. And they pursue very aggressive tactics with people, very aggressive enforcement tactics to not so much enforce the law, but enforce what they wish the law would be. And I defend a lot of people, a lot of small businesses when the regulators come and, they sort of throw their weight around and they try to get my clients to enter into quick settlements or in some cases shut down their businesses because the regulators, for whatever reason, have decided that, a very aggressive interpretation of the law is appropriate and they just don't like something that one of my clients might be doing, even if it is legal. So, we're an organization. We provide pro bono services to people who are really victimized by administrative agencies. And, we try to defend them, and we also, turn around and we sue the agencies when they step over the line.
Well, that's really important work, and thank you for your efforts in doing that. And I should tell the audience that you are a litigation attorney, so you're not really reliant supposedly on motion practice. You are a man in the arena, speaking, battling with judges, the opposing, the prosecutors, the regulators, and also hopefully sometimes in front of juries.
Yeah, absolutely. And, one of the things in administrative law that, is a real focus for me is, unfortunately, administrative agencies like the Securities Exchange Commission and, particularly financial regulators, they like to go after people in administrative settings, and they like to try to keep people out of court, traditional courts, and deprive people of their right to defend themselves in front of a jury. And that's, that is a tactic that prosecutors and regulators love. And that's something I really push back on. My goal is to get these cases out there in front of people, in front of ordinary people in the community, in front of a jury, because, I think when people see these abuses of agency power, and, actually see what's going on, they have a much different take on it, and I think the agencies love to hide it. They love to put it in, behind a wall, really, so that people don't know what's happening.
Yeah, I agree 100%. And talking about, I come from obviously Wall Street. I worked on Wall Street for 25 years, so I'm very aware of the financial remedies practice there. As far as the National Futures Association looks at as much as registration, as far as the futures industry, they can be enforcement at some point. They work exclusively with the CFTC, the Commodities Futures Trading Commission, which is the government arm for derivatives and futures. Then you have FINRA, which is the governing body for the most part of securities regulation and registration. And then they work hand in hand with the Securities and Exchange Commission. And most of those appellate processes or remedies, exhaustion of remedies, has to go through those people before you even get to court, right?
Yeah, absolutely. And, and you mentioned before, I come from a public defense background. And, while what I do right now is I deal with administrative agencies, I deal with regulators, unfortunately, it's the same kind of story in criminal law too. Because, I'm sure most people are familiar with the statistics. Vast majority of cases, people plead guilty. And, really the system is designed, and the system I'm talking about is either regulations or criminal system. It's designed to keep people out of court as much as possible and keep them pleading guilty. Because, the prosecutors will all tell you it's so that we can be more efficient. But a lot of that is they want to keep their cases away from people. They don't want people to see the kind of cases they're bringing. They don't want to see, juries to see that. And they don't want it out there. They want to try to just settle it on paper, get people to plead guilty and move them through. And so, it really is, it's kind of a theme in all of my work. And, I always say, trials are so much better. They're risky if you're on trial, for sure. But, I'd rather hand my fate to a jury and, just normal people than a prosecutor any day.
Yeah, I think that's a topic for another day, the trial,
Sure.
the trial disparity of the risk of going to trial versus pleading guilty. We know statistically from the U.S. Sentencing Commission that I believe now over the past couple of quarters, over 98% of defendants plead guilty instead of going to trial. And there's been a huge rise on not only whistleblowers on the regulatory side that's opened up recently in the past few years, but also the usage of what's called government informants or 5K1 letters of cooperating agreement with the government that they rely upon to get people to plead guilty as well.
Yeah, absolutely.
Yeah.
And, one of the things that you and I talked about before, I think is, you mentioned the cooperation agreements, 5K 1.1. That all comes down to the same thing, which is the power of the prosecutor. And I know that's really what I'm here to talk about. And it's just, there's a reason why there's that situation. And I guess that's probably what you want to talk about.
I do. And, actually my first question is, we just had a presidential general election. And some people have stated, through my life, the president is the most powerful person on the planet, right? Because he's in charge of one of the biggest nuclear arsenals in the world, and he runs the largest economy in the world. So it's a very powerful position. But our elected officials, who we elect as well, both state and federal officials, are also very powerful. They enact the laws, on behalf of the citizens. But the question I say to you is that for the average American citizen, who do you think could have the greatest influence or power over somebody's livelihood or liberty? The President of the United States, an elected official, or a regulator or a prosecutor?
It's definitely a prosecutor. And I have to temper that a little bit because I used to be a prosecutor. And I certainly don't feel like I had a lot of power as a prosecutor. And so, I always tell people that most important election in your where you are is the DA, is the elected district attorney, because that's who's in charge. And they make all the decisions in a criminal case, and the prosecutor's office, and they hold all the cards because, there's a variety of ways that a prosecutor can, take a case that might not be much and make it into something really life-changing and, destructive. And, working in a prosecutor's office, it's hard. It's the hardest thing to do sometimes is the right thing. because, it's 10 times easier to get somebody to plead guilty on a marginal case than it is to go to your supervisor and get them to dismiss a marginal case. And there's so much sort of institutional power there. But, I can talk in abstracts, but, just think about just a simple kind of a case. I mean, let's say it's drunk driving, something that unfortunately a lot of people have a relationship with, There's a lot of ways to charge a drunk driving case. And maybe you charge drunk driving and also, driving on a suspended license and a moving violation and reckless driving, and you keep adding up charges. And that's a way that a prosecutor can say, you know what, I'm going to make this so much worse for you that you're going to plead guilty to this one offense because it's, I've just stacked all this on top of you. And there's a lot of, say, minimum sentences that are required under different laws that only happen sometimes that we can trigger by the way we've charged it. And so many of these decisions are only made by the prosecutor, and the judge can't do anything about it. The defense can't do anything about it. And, they can have profound consequences. I mean, you can charge one case one way where somebody's not looking at really much time in jail at all, say, and you can charge another way where, it's years and years. And so you're absolutely right. I mean, it's the prosecutor, they have all the cards, at least in court.
Sure. Maybe you could explain to the audience a little bit, that example, that the idea of stacking to really kind of scare the hell out of somebody to plead guilty. We know that on the statutes, they face, civil fines and imprisonment times on each statute, right? And so you're looking consecutively at 30 years for a drunk driving case. Let's say you've done it 2 or 3 times, right, because of enhancements or what have you. Mm-hmm. Do you think the defense does a good job of explaining the difference between what the chances are of serving like 30 years for something versus that most of those sentences will be run concurrently, even if you're found guilty, and what your risks are and what's your risks under what you would actually serve? Do you think that the defense attorneys really break it down for clients to say, okay, here's your risk reward?
I think not always. And I think that's a real problem. Most criminal defense attorneys, we work in the system and we know the people, we know the players, we know the judge, we know the prosecutors. Most of us work in, one jurisdiction primarily. And, I think there's a tendency among defense attorneys, and it's unfortunate that, we're really just trying to process through our cases. And sometimes that turns out, we're just trying to get a client to plead guilty. We don't think there's a really good defense. We're just trying to get them to the finish line, right? You just try to talk them through and try to get them to plead to something and dispose of the case, move on to the next one. And I'm not saying everybody does that. And there's some great defense attorneys out there who don't, and they're going to fight everything. But that is a tendency. And, you use the term stacking. This is something that comes up in federal criminal cases. And, that is actually refers to a very specific thing where, there's a particular firearm enhancement that they can give you where, let's say you commit armed robbery. If you go out and you commit an armed robbery, let's say you do 3 armed robberies, like a spree, Friday, Saturday, Sunday. Most times in state court, you could get charged and they might charge you and you might be looking at, 5-6 years in prison, which is, some serious time, honestly. If the feds go after you for that same action, and let's say you have a gun involved in the robbery, they can charge you for all 3 of those crimes. And for the third one, they can charge you as having committed a crime after having committed 2 prior crimes, even if you haven't been charged or convicted or anything. So they can charge you with all 3 at the same time. They can enhance your sentence based on all 3. And then they can stack the gun charge on top of you. They can give you a mandatory 10-year consecutive sentence for every gun that's been used in the crime. And actually now if you've brandished it or if it's been more than one, they can enhance those sentences on and on and on. And it's very easy to get up to a sentence that's like a mandatory 50-year sentence in federal prison. And, really the kind of power that we're talking about is most pronounced in federal court. federal prosecutors have unbelievable tools at their disposal to enhance sentences with mandatory enhancements. And, like I said before, the judge doesn't have anything to do with that. The judge can't say no. And, there are lots of instances where people have fought their cases in federal court and they've ended up with life sentences on cases that, across the street in state court, they might have gotten 10 years on.
Yeah. Well, I've known a lot of those cases. I've had the fortunate of working on a lot of cases for a lot of guys, so I know exactly how punitive the system can be, and that's why this area topic is so important. So what I've done is prepared, Caleb, a number of examples for the average citizen can kind of see what we're talking about. They don't really know the lens of what you and I have seen. They read some things in the paper, but they really just don't know. And the cases primarily that I'm going to bring are cases that I'm aware of. I'm mostly, like I said, a Wall Street guy, so I know mostly white-collar cases, and I know some disparity cases and how the prosecutors have handle certain cases. So I'm just going to walk through a couple of them and let you opine on some of them, some ideas that may pop up. The first thing, before I get into examples of specific cases, is I wanted to ask you about the power of prosecutors through kind of the government. So selective prosecution weaponized through political power. And one of the ones I'm bringing up are recent examples of Steve Bannon, Roger Stone, Paul Manafort, General Flynn, Rick Gates, George Nader, George Papadopoulos. These were all recent cases where there was kind of a political tune to prosecute all these. I'm not saying that the merits of the cases or anything like that, but how did those cases get risen to the top of the pile to start prosecuting?
Well, there's no doubt about it that those are political in a sense, right? I mean, we can maybe agree even if, some of those seem to be, there's some basis to them, right? I mean, several of those people you mentioned, they went to trial or they pled guilty or something. There's probably a crime there. But the reason those cases were brought is because of who those people were and the relationships they had to the president and the political reasons, right? I mean, when you talk about selective prosecution, you talk about political prosecutions, prosecutors always come back and they say, no, there's something there. See, there's a crime. It's not selective. They committed a crime. I'm prosecuting him just the same. And, we all know that's phony. And it's really not an excuse, right? I mean, yeah, of course, there's something there. You found something, but you didn't look at him in the first place. The reason you looked at him is because you were looking at him because of who they were, and I mean, let's just not kid ourselves. When I was at the DA's office, that happened too. I'm going back to New York where I was a DA, my office prosecuted Dominique Strauss-Kahn. I don't know if you remember that case. Yeah, it was sort of infamous, and it was a big political thing, and the press is outside the office every day. It's like, obviously that case was the case it was because of the people involved, and it's juicy and it's all over the tabloids.
Right. So how much of a threat to that is to the independency of a district attorney or the Department of Justice when they start weaponizing political cases?
Well, I'll say this. Historically, you see more of it in local offices, right? Like a locally elected DA, they're a political person, so there's always a little bit of that because they want to try to get reelected. Hopefully, the Department of Justice is more insulated, right? Because United States attorneys are appointed, and there's traditionally been a decent separation in politics. I mean, there's always some, but they've done a pretty good job. And I think it's really concerning now in the last few years, there's really been a shift that we've seen where there's more and more politically motivated prosecutions, political actions. And in this administration, we've seen an interesting kind of divergence where you have main justice on one hand, and you have local offices pushing back. And they're all sort of staking out their political territory. And, that's really concerning. And it's concerning that an office like this the Southern District of New York has its own agenda, and sometimes they're fighting with main justice on this. That's not good for anybody.
Right. So the audience doesn't know the Southern District of New York is considered the mother court, the most powerful U.S. Attorney's office in the country, right?
Yeah. And, there's been, over the last few years, there's a fight now between the federal prosecutors in Manhattan and here in Washington, D.C. and the Attorney General. And it's ugly. And that's really what the Flynn case is all about at this point, where there's a disagreement. There's a disagreement between the Attorney General of the United States and a line prosecutor about whether they should have prosecuted General Flynn and whether his guilty plea should be thrown out or not. And you have a really bizarre situation where the prosecutor is saying, I want to dismiss this case, and the judge is saying, no, I'm not going to let you. Yeah. And I think from a defense perspective, right, I don't care about politics on this one. I don't like a rule like that. Yeah. If the prosecutor says there's no case, there should be no case. And that's deeply concerning for me.
Right, exactly. But at the other side there, we're talking about the absolute power of the prosecutor to bring cases. Very rarely, what percentage of cases does the prosecutor, especially a federal case, do they withdraw? Not that I'm aware of.
Well, and obviously there's a reason that case raises a lot of questions, because it's really unheard of what's happening there. The idea that the prosecution has just suddenly decided to dismiss it for no reason is, that obviously the judge sees a lot of red flags. So do I.
Sure.
There's so many political considerations. Yeah. But I guess that, it's really all, so much of this is just pretense, right? Because I can talk all day about these cases that I know are selective, they're political. And courts always pretend otherwise. Prosecutors pretend otherwise. Even defense attorneys, we have to pretend otherwise. We have to say, well, it's not really what's going on. And again, like I said before, it's, well, as long as there's something there, it doesn't necessarily matter why we did it. It's just, well, we found something, so, don't look too hard.
Yeah. Well, I know that there, Judge Rakoff in the Southern District of New York, I know that he's been one of the ones that I'm aware of over the past couple of years that have questioned settlements. I'm not sure how. You might be aware of more judges out there who are not just rubber stamping and thinking that they're glorified clerks for the U.S. Attorney's Office. They're actually more powerful. They should be more powerful than the U.S. Attorney's Office. And so I don't think they take kindly to thinking they're clerks.
No, and Judge Rakoff actually, something very interesting. We talked about regulatory enforcement and regulatory settlements. Judge Rakoff really staked out a pretty strong position a few years ago about that. There's a practice, particularly with the SEC, where they'll enter into a settlement with someone, and a lot of times a very substantial settlement, and they'll enter into an agreement where neither party admits, nobody admits nor denies the allegations, but they've settled them, and there's substantial penalty, and then we all sort of move on. And then the agreement actually says that the settling party can never suggest that the prosecution was unfounded, but they're not admitting anything. And Judge Rakoff was very concerned about that practice. And he said, on the one hand, you're muzzling these people from ever saying that there was, that this prosecution was misguided or there was something wrong with it. And on the other hand, you're taking this huge amount of money and nobody ever admits anything happened. And then you're just asking me to rubber stamp it. And, unfortunately, that's a part of the practice where, the federal government, the U.S. Attorney does this too, by the way, but, the SEC, the criminal prosecutors, they extract this huge amount of money in these settlements, and there's very little public scrutiny. And sometimes that's by design. These agreements, you're not even allowed to talk about them. It's like, we've paid our hush money.
Exactly. And what do you think the process is when some of these really explosive cases where the government is able to get tremendous civil penalties, disgorgements, forfeitures? What is the record of the actual people that have been defrauded, the victims, actually recuperating that? Is at some point, I mean, especially the Southern District, who takes an extraordinary amount of money. I mean, is this a revenue maker? Have they weaponized and monetized the courts as kind of like a hidden tax? Or are people actually getting, reciprocated back for the victims of fraud, for instance?
No. And it's, the clearest example, there's something called disgorgement that the Securities and Exchange Commission likes to do. And, this was kind of just invented out of thin air in the 1960s, but it's been a part of the SEC's toolbox for a while now, where what disgorgement is supposed to be is, when someone takes money from someone else because of fraud, they defraud somebody, they get money they're not entitled to. Disgorgement is supposed to pay it back. You have to pay it back to who you took it from. Okay.
What's the difference between disgorgement and restitution?
Not really supposed to be anything.
Okay.
And really it's supposed to be just terminology. So it's like restitution, right? If I shouldn't have gotten those fees from you, I have to give them back. But what the SEC has been doing more and more over the years is they've gotten courts to give them disgorgement, and then they don't have to give it back to anybody. It goes back to the US General Fund. So they'll take this disgorgement fund, they won't give it to any victim or anyone. They'll just take it. And in some cases, they'll take the gross amount of money that was involved in a particular case, not what someone netted improperly. So instead of being restitution where they just have to pay back what they got, actually it ends up being this really inflated number of just money that passed through that then the government just takes. And then they do whatever they want with it.
Right.
Fortunately, there was actually a case in the Supreme Court this last year that, the court said, wait a minute, you can't do any of that. That's not what disgorgement is supposed to be. And we're still kind of waiting to see how that's going to play out. But I mean, this was a main tactic for years, the SEC. I mean, and we're talking about billions of dollars.
Well, I mean, talking about FINRA, FINRA, the last time I looked a couple of years ago for not-for-profit, I had like $2.5 billion sitting in their things. And they have a revolving door of SEC and FINRA officials going back and forth. These guys, the CEO makes a couple $1 million a year. I'm not sure what the average lawyer, at FINRA makes, but it's a huge moneymaker. And maybe going back to your point before, behind mainland justice at the Department of Justice in Washington and the battle with the Southern District is that, hey, this is our main boys. Southern District brings in a lot of money, so they're going to stand up and say, hey, we're revenue producers here. You don't talk to us like that. We do what we do, Well,
and, this is probably like a silly point, but, one of the sort of unique things about the SEC while we're talking about it, they're on a different pay scale. So most federal employees, they're on, this government service pay scale. And most federal lawyers, they make the same as other federal lawyers across the government, except for the SEC. They have the SEC pay scale, and it's a lot higher. And, the agency says, well, we need good talent and financial markets are confusing. But, really, a lot of that is because they bring in so much money. The SEC is a moneymaker. They get a tremendous amount of money from the people they enforce cases against. And it's disgorgement, it's fines, it's all sorts of things.
So let's start looking at a couple of cases that the average citizen we can relate. The average citizen can relate to. All right, Caleb. So you actually sent me one. So we know that in the spring or late summer, what have you, we had Black Lives Matter. We had the murder of George Floyd that we all saw, and millions of people took to the streets. They saw a human being murdered, and for the Black community, it was just a one too many now. It's just over the top. And so whites and blacks took to the streets, and I don't know who they're talking to. They're talking to somebody. They want somebody to do something, right? They want change. But the municipalities throughout the country are left with all these people. So the first thing that I kind of want to know is, I don't know if you know or not, but we have in the First Amendment the right to grievance the government. We have the right to assemble, right? But when mass protests go out like that, I'm not talking about vigilantes and violent stuff. I'm talking about people just taking to the street with signs and just not asking for, being granted permission to do it. But what are the local municipalities, the police officers, what are they prosecuting? You sent me a case where I know where I'm from in Jacksonville, Florida. There were 70 people arrested during that few-week period of protest. And I think they dismissed 67 of them. There's 3 of them they held. But you sent me a case that I think the title was "The Feds Go After Protesters with Rarely Used Civil Disorder Law Enacted in 1960." So like you were saying earlier, the difference between when they really want to get somebody, leaders in the protest movement or whatever, they can bring them in locally. And then if they really want to ramp it up, charge them with a federal crime. So explain to us a little bit as far as, those types of protests, what happened? Are there people sitting in jail? From that? Everybody kind of has moved on from it a little bit. They're still in waiting now, some type of resolvement, some type of new changes to laws, accountability. Actually, my guest next month is going to be Anya Bidwell. We're going to talk about the idea of qualified immunity, sovereign immunity, absolute immunity, of holding accountable, our police officers, our government officials. But maybe explain to the public a little bit about, what's the role of the police, the federal government, to kind of deal with these mass protests?
Yeah, so, I think Philadelphia is a great example of what you're talking about, where, Philly is a very interesting place politically. And, I spent time in Philly doing criminal defense work. And you might know that in Philly, they have an elected DA who's very progressive, Larry Krasner. He's a former defense attorney. And, he made a lot of headlines across the country. He's very progressive. He's, against cash bail, these sorts of things. He's about reform because, police reform, Brady reform, disclosing exculpatory evidence, all that sort of thing. Unfortunately, he's had a really contentious relationship both with the police department in Philly and also the United States Attorney, who's, a recent Trump appointee. And they've been very vocal and they've really been fighting. And over the summer, we see all these protests and, there's a lot of protests in Philly because unfortunately there's a real problem in Philly with police violence, like a lot of places, but it's, there's a real culture there of police violence and lack of accountability where, there's very few consequences when the police get out of line. So there's a lot of protests. And we have at least one case where, some people were protesting and it looks like maybe they were caught setting fire to a police car, which is, that's unlawful. That's not First Amendment protected speech. But, if you get charged in state court and if Larry Krasner's office charges you, you're going to get charged with a misdemeanor, probably for, criminal mischief or something like that. You're looking at a fine, probation, something like that. It's serious, but it's not that bad. What happened is the US Attorney charged those people federally with federal felonies, rioting, arson. And the arson charge actually carries a 5-year mandatory minimum sentence if you're convicted. And these people are being held pre-trial. And one of the people is, a Black Lives Matter organizer. He's a teacher in West Philly. He's well known. And a lot of people, I think, are, rightly saying this is political. This is because the U.S. Attorney is fighting with Larry Krasner. They had a press conference after the arrests were made. And this is a political prosecution. This is, we're taking the might of the federal jurisdiction where we can just nail these people and send them to prison for a long time for stuff that should be charged in state court and should be relatively minor. And that's absolutely right. And the problem is, like I said before, when you go into the court and you go in front of the judge, you can yell and scream until you're blue in the face. This is political. And everybody knows it's political. But if they set fire to the car, say, it doesn't matter And the judge is just going to go along with it. And he's going to say, well, what do you want me to do? And arson has a 5-year mandatory minimum in federal arson charges. If you get convicted, you're going to go to prison for 5 years. The judge may not like it. He doesn't have a choice. And so this is a situation where, these people who are being charged, they're caught in the middle of a political fight, and it's their lives. And the only difference really is the prosecutor and who's in charge here and who gets to make that charging decision.
Absolutely. And so in that leadway, what I thought about was a similar movement after the financial crisis of 2008, 2010. And there was, just an outrageous uprising of people went out there. It was called the Occupy Wall Street movement. It was same general idea as Black Lives Matter, is that it was kind of trying to decentralize a little bit so you can attack the head of the snake, right? So that it's more difficult for law enforcement to kind of squash. Their favorite term is, if we cut the heads of snakes, it's a deterrent to anybody else who follows, and it's probably a pretty efficient way to deal with it. But so during that time, there was an example of Goldman Sachs, who later on paid Goldman Sachs traditionally in the papers and stuff are called government Sachs. We have Steve Mnuchin is the Treasury Secretary. We have Gary Cohn, who was in there. They often have a revolving gate of powerful government officials going back and forth from Goldman Sachs to the government. That's widely known. So Goldman paid $5 billion in fines for mortgage and securities fraud. No control person was ever named. And why is the control person important? Because the control person statute gives the ability of prosecutors to reach behind entities, to hold accountable individuals who actually committed the fraud. And what has been ongoing, as you well know, is that the $5 billion is paid by the shareholders. It's not paid by individuals, and it's a business model that just goes on and on and on and on. Goldman Sachs is not alone. J.P. Morgan over the past 15 years has paid over $30 billion of fines, and no control persons for the most part has ever been named. Merrill Lynch as well. So recently, and this is where it just goes on, is that Goldman Sachs, starting I think in 2010, there was a guy by the name of Timothy Leissner who was the head of Goldman Sachs in Southeast Asia. And he worked with the Indonesian government on a fund called 1MDB, and it's basically a Malaysian sovereign fund. Eventually, Goldman helped them raise about $6 billion, and Goldman received over $600 million in fees. This guy Timothy Leissner received personally $43.7 million of that for setting this up. It ended up being total fraud and stealing from the people of Malaysia. They ended up the people who did it. A guy named Joe Low was indicted in the U.S. He's been trying to be held accountable in Malaysia. He's in China somewhere, so he's never stepped foot in a court in the United States. Timothy Leissner was charged. He was never denied bail. He had a $20 million bail, so he's been out free. They charged him in July of 2018. He pled guilty in August 2018, and he's gone through what I call the two-headed monster, basically criminal charges and regulatory charges, which are debilitating, right, for most people. But this guy obviously is going to pay back $43.7 million, supposedly the exact amount he made in the huge, fraud going on. The Goldman paid additionally in Malaysia and I think in Europe another $4.5 billion. What's interesting here is that we're talking about the power of the prosecutor. Timothy Leissner pled guilty in August 2018. We're now, past 2 years from that, which is very unusual. He's obviously a cooperating witness. He's come out instead through his lawyers or himself stating this was a culture at Goldman. I I'm not a rogue guy. This is a policy. This is a model of how we make money. This is only one product that we're doing here, and this is only one. And we know that people like Gary Cohn and Steve Mnuchin, who are very powerful people, know the balance sheet of Goldman and where they're getting their money from, right? And so to have $600 million hit the balance sheet, they've got to try to figure out how to manipulate that or kind of, kind of keep it secret for a little bit. So this guy's not acting alone. I don't know exactly what names he's naming, but he's saying it's a culture. So he's a cooperating witness. We're talking, he's looking at with these type of numbers and the enhancements that you're talking about, decades in prison. For a normal guy, he'd be in jail right now. I mean, if there's anybody, there's two ways to hold somebody, deny them bail, right? There's a flight risk and there's a safety to the community. This guy is a very wealthy guy. He's traveled all over the world. I mean, if he's not a flight risk, I don't know, but he's been out of bail, from day one. And so, and he's still cooperating. He's still not been sentenced, and it's going to be a case to watch for, because I know we said we were not going to get too much in disparity of sentences, but this case, William Barr, the acting Attorney General, and another guy who's a high-ranking official in the Department of Justice, who actually just resigned, both worked at Kirkland Ellis, who were Goldman Sachs attorneys. So Goldman Sachs, at the end of the day, neither admitted or denied. Again, they've got a really great disposition. They've paid these fines. They're going to hold one or two guys, accountable, at least finally somebody, through the entity. And so, what do you think of a case like that, where less than a decade apart, where Goldman Sachs commits, and Goldman's, I'm not picking on Goldman just specifically, but egregious violations where we're talking about the normal everyday businessman has his head cut off and he's in jail, right? For whatever, if he does anything close to this. And then this model is just ongoing. Shareholders pay a fine. No control persons are named. That business model of the idea of what's called regulatory capture, which is the regulators and the prosecutors kind of protect our biggest organizations and take the legs out from the smallest guys.
Yeah, I mean, that's exactly what it is. It's after 2008, there was all kind of talk. We're gonna go after the people that caused this problem. We're going to stop the fraud. We're going to get some people. And that's not really what happened, right? A lot of big organizations, a lot of big companies, they paid something. Goldman Sachs paid something. They didn't admit anything, no wrongdoing, and no individuals were prosecuted. Now I think there's a little bit more of a culture that we got to have a scapegoat. We need at least one person, but it's not. The US Attorney, the SEC, they don't ever try to shut down even these companies that are repeatedly in trouble. They're repeatedly caught doing bad behavior because it's too disruptive. And it's much better for the regulators. It's much better for the prosecutors. We'll get a giant settlement. They'll promise they won't do it again. The shareholders will pay the settlement. And then, we'll take one or two people down. We'll charge one individual and see we did something. But there's never really an earnest effort, I think, to get everybody that actually committed wrongdoing, at least in a big company. In a small company, it's exactly the opposite. I mean, they'll prosecute everybody. Those cases all end up referrals to the U.S. Attorney. The SEC will start an investigation. They'll refer it to the U.S. Attorney. They'll criminally prosecute everybody. Those guys aren't making bail. They're not paying $20 million and walking out on the street. They actually calculate the guidelines against them, and they're saying, you cooperate and we'll only give you 5 years. We're not going to give you 10 years. And it's a complete different system depending on the size of organization you're at, the size of the company. I mean, you may want to talk about it later. I don't know. But like Purdue Pharmacy, I think is another great example. Purdue got caught in 2007 for essentially what everybody's talking about now, where they were misbranding and promoting OxyContin. They were prosecuted. by the feds, and they agreed to a deferred prosecution agreement. They agreed to pay about $600 million. No individuals were prosecuted. There was really nothing more from it. And Purdue said, sorry, we won't do that again. Fast forward 13 years now. Well, they just pled guilty again. Now they're going to pay $8 billion. No individuals are being prosecuted, and Purdue is just going to declare bankruptcy and reform and continue selling the same products. It makes great press. The U.S. Attorney is very happy. We got $8 billion from Purdue, but nothing really changes.
Well, I think they got $222 million from the Sackler family as well, and then I think they said that they may earmark another $3 billion in maybe a wider, different type of settlement. I'm not exactly all the legal things because states and there's all kinds of lawsuits going on. But through the records, the Sackler family took out over $10 billion over the past 10 years, kind of knowing they were in trouble. So I don't know, if there's going to be clawbacks and stuff I'm sure there'll be legal arguments to that, but.
Yeah, and look, it's going to be a huge mess, and I'm not really interested in. To be honest, I'm not interested in more people being prosecuted. And I know the Purdue case is going to be messy. There are billions of dollars moving around left and right. People are fighting over it. And I don't know how that's all going to shake out. But it's one of those situations where, it doesn't really seem like the government has been interested, at least not in 2007, in actually addressing what's the real problem, which, is marketing OxyContin and other opioids in a way that really, preys on people and cause a lot of overdoses and addictions and, really facilitates addiction. And that's the real problem, right? And in 2007, it didn't seem like they cared about it. A lot of it was just, the press and extracting a settlement and we're going to move on. And that's just, that's not what you hope for in a prosecution and in your prosecutorial entities or with Goldman Sachs. You don't want them to just take money from the shareholders and get a big fine. It's like, actually, can we just stop the bad behavior, right? That's what you want. And then, as long as you're big enough, it's okay. But if you're a small company, if you were I know there's not that many small pharmaceutical manufacturers, but if you're small, like compounding pharmacy or something, and we're talking about the same sorts of violations, those people would all be in prison.
Yeah, well, that's really the Goldman Sachs and JP Morgans and Morgan Stanleys and Merrills of the world. They're stealing money on Wall Street every day. That's known, and that's a frustration for everyone, right? They're the ticket booth, they're the tax collector. And they've set themselves up for 50, 100 years, and it's frustrating that we can't enact policy to, that they still make billions. When they want to steal additional billions is where it gets frustrating, and you're locking guys up for bouncing checks. In George Floyd's case, supposedly bounce a $20 check or a $50 check, whatever it is, and killing the guy. That's where their outrage is. It's just like, come on, we can tolerate a certain amount. I think the Purdue pharmaceutical thing is that, for 30 years we have a war on drugs. Okay, that's the policy of the United States. Hey, we're going to go after the narco guys. We're going to go after the producers. And here you have domestically, pumping millions and tens of millions of pills into small towns with 200 people. You're not that dumb. You know what's going on. And yet you let it go on, and you have whistleblowers for years saying, hey, what's going on? People are dying in the streets. And that's where it gets, I think, frustrating, Caleb, that you see such a disparity. You got guys rounding up 6'10" black guys in Harlem, shaking them down and getting a few bags of crack or a few joints, and going to Rikers and getting their ass kicked or getting killed or sitting there without bail. And meanwhile, the Sackler family has got $10 billion. They've got a mountain of lawyers in front of them, and they've got the government had protected them up to a certain point, and now it's like a money thing. But that's thousands and thousands of deaths later and decades in the making.
Well, I'll tell you just a story from my own experience. I had a client who a few years ago was charged with murder for he was addicted to opioids, and him and his girlfriend went out and they bought some OxyContin on the street. And it turned out it was, they were fake. It was fentanyl coupled with other things. It was stronger than they expected. He bought it. He took it. He gave some to his girlfriend. She died. She OD'd. And he was charged with murder for that. And on one level, that's the approach, right? And that's the war on drugs that you're talking about. And that's been, we're just going to incarcerate our way out of a drug problem, an addiction problem. And then Purdue Pharmaceuticals and the people who are pushing these drugs and setting up the problem, those individuals are just paying fine. So, this isn't hypothetical. We see it every single day.
And it's happening in real time. So we don't have, I just want to get through a few things because we're running out of time, but I wanted to just bring up a couple of examples of, additional kind of, we talked about, they are eventually, it seems like begrudgingly bringing cases when it's like the last resort that they can't get through it. They can't do dispersion agreements, which are agreements that they don't charge prior if they fix things up. They didn't even do that in many cases. One of the funniest cases that, not funny, but a couple of cases here is the Elon Musk case. I don't know if you're aware of it. So you talk about marijuana. The dude likes to smoke pot, I guess, and so he just, he's one of the smartest guys on the planet. He's doing amazing things, right? But he's a little reckless. He just says, "Oh, I have a buyer of $420 for my company Tesla," and he just fabricated the whole thing, and he made up the $420 reference, some type of reference to marijuana. It was securities fraud. We have guys in Staten Island and Brooklyn who are running boiler joints who do the same thing. Now, I don't know if Elon sold any stock or anything like that, but it's securities fraud in any way, shape that you look at it. Again, we're looking at guys getting locked up for trading ahead of a rumor or something like that. Securities law is basically trading on non-public material information and acting upon it, right? I guess he didn't act upon it, but he pays a $20 million fine. He's charged civilly, not criminally. He's got his hand slapped a little bit of what he could tweet, what he could do, how he could be represented as an officer in Tesla and stuff like that. But he's the fifth richest guy in the world. He's worth $30 billion or whatever he's worth. So $20 million to him. In the month of August, when Tesla eventually went to pre-stock split, $2,500 a share, he was making like $20 million an hour. So for basically an hour, he paid the fine. If you take the average guy who gets charged a $250,000 fine and makes $40,000 a year, his life's ruined. Plus the lawyers he pays and whatever. Elon Musk has a whole army of lawyers built in at his company that he pays for.
That's nuisance value to him. Absolutely,
it's just nuisance. And he still thumbed his nose at the SEC. He still was like whatever because this dude just obviously doesn't get it. That he doesn't know what's going on in the world. That people are in jail for far less than what he did, and he thinks he's some type of privilege and stuff. The other case. Is now we're talking about race. Now, we're talking about race. And so from what I understand, the richest black guy is a guy named Robert Smith, who runs a private equity company called Vista Equities or something like that. It's a private equity firm. If people don't know what private equity is, it's primarily an old boys club. They get up together, they buy undervalued assets, they try to flip it, and then they sell it to other people. So it's an insider type game. They make an awful lot of money. He's worth, I guess, $5 or something billion. He had evaded taxes for a number of years. From what I read, it was over $30 million. He's going to pay a $139 million fine. He's not going to be prosecuted criminally. But what he did was he helped. He became a government informant, and he helped the government roll over on one of his clients, a guy named, I believe his name is Robert Brockington or something, a tech guy who evaded over $2 billion of taxes. And so they're going to prosecute the hell out of that guy. But Robert Smith will not spend a day in jail. And he's been out there giving money to Morehouse College and other people and looking benevolent. John Gotti used to give out turkeys at Thanksgiving. He probably found them. It fell off some truck. He probably didn't pay for them, and he gave it to his community. He's a great guy. He's a benevolent guy, right? And I think Bernie Madoff was also a pretty charitable guy. It's pretty. You can be charitable when it's not your money.
Yeah.
But one of the things I wanted to get to is that, did you work with Benjamin Lawsky?
No.
You didn't? Okay. So one of the things I want to just kind of close up here in the next few minutes is we wanted to talk about the role of prosecutors entering to a whole different asset class, like digital currencies, cryptocurrencies they're called, like Bitcoin. People know Bitcoin or Ethereum or Ripple. They know it. It's interesting. There is lots of fraud going on in that arena. So we do need the prosecutors to look at it. I personally have been involved in one case, a guy by the name of Randall Crater and My Bitcoin. I wrote an amicus curiae brief on his behalf a couple of years ago. He wasn't even the officer of My Bitcoin. It was owned by another guy named John Roche. I wrote it because the CFTC was trying to establish jurisdiction, and they're in charge of commodities and derivatives, and they were trying to make a money hold, a grab hold on cryptocurrencies, which Judge Seibel up in the First District of Massachusetts was able to do. Randall was actually hired as kind of a contractor to develop the software. He came from the gaming community. And so in his case, it's been going on 2 years now. It'll be almost 3 years now since he's been indicted. And I don't know if you know about this, but he had motions in to dismiss in the First Circuit. I think that's Massachusetts. And supposedly in Massachusetts, you cannot go to the appellate court. You got to actually ask permission from the district court to appeal a district court's decision. Do you know anything about that?
I don't. And I don't know, is this in state court?
No, federal court.
So, it depends sort of where you're at. I mean, so there's what's called an interlocutory appeal, which is when the case isn't all the way over.
That's what it was. An interlocutory appeal was denied. The district court made a decision, and then they did an interlocutory appeal asking permission, the judge, can we go to the appellate court? Yeah. And the judge said no. And somehow that's allowed. I'd never heard of it before. Yeah.
And you know, that kind of goes back to what you were saying. I mean, that sometimes the cost and the anxiety and the uncertainty of defending a case is enough to make you plead guilty, because there's just so much to it. And it's so hard to get to the finish line sometimes. And I mean, in that case, you know, there's a question about whether what I did is even in your jurisdiction. And, you know, when the judge says no, and oh, by the way, you can't appeal until this whole thing is over, and you're talking about years later and, you know, hundreds of thousands of dollars in fees, that really just means I'm going to have to settle, or I'm going to have to come up with a way out of this in a lot of instances.
Yeah, in his case, it's been millions of dollars. And his case is basically defrauding 28 investors out of 6 million. So his livelihood, his career is down. And so we didn't really talk much about that, but the idea of just being alleged it could be tremendously punitive. It could destroy your livelihood. Forget the prison and the civil penalties down the road and the cost of attorney's fees to defend you. 3 years in on a federal case, both civil and criminal, is extraordinarily expensive.
Well, and you know, that's part of what I do at my organization. You know, I have a series of clients right now who, you know, they were charged by the Securities and Exchange Commission, and you know, essentially they were charged with just being sort of too close to other people who committed fraud, and you know, it's one of those cases that it's unjustified to bring it in the beginning, and it's really the commission is taking a view that's really out, you know, kind of out there and beyond what the law says. But just the fact that they brought the charges, you know, they can shut down the business through just reputational damage. And, you know, in the ordinary case, I mean, these are hundreds of thousands, if not millions of dollars in legal fees to fight the case. Most people make the reasonable decision to just settle in that instance. It's cheaper in the long run to just say, you've got me, because I can't even afford to defend it. No. And I mean, I think that's another component. It's not just the charging decisions. It's not just, the fact that this case, there's so many consequences in the end. It's that in some cases, it's just so hard to fight back. It's so expensive that there's no reason to fight, and a lot of people in my situation, a lot of defense attorneys, that's the first conversation we have with our clients. It's just like, you got to settle this. You got to come up with a number because it's going to be more expensive to prove you didn't do anything wrong.
Yeah, no, absolutely. That's all a definite model. So going back to Benjamin Lawsky and a guy named Chris Giancarlo, who calls himself, calls himself the crypto dad. He was a guy who worked in interbank derivatives at a firm called GFI for many years. Somehow he got to the CFTC as a commissioner and became chairman. And his sole purpose on that CFTC was basically to get jurisdiction for the CFTC for cryptocurrencies. And now he works for a law firm, Wilkes Farr, I think it is. Benjamin Lawsky basically was a New York State administrator, the very first one, financial. They set up a whole new area. He basically enacted all the policies and laws of digital currencies and then set up shop like less than a year later. And everybody has to really comply with what he set up. So what's your feeling on, really know the ability for somebody to go into public service, set up like cryptocurrencies here, because it's very timely, set up a whole new business just for themselves and other people to comply with, and then be the gatekeeper and make tens of millions of dollars on that? Should there be some type of rule or something that they have to wait out or sit out for a while? Or this isn't lobbying. This is actually setting up a business while you're in public office and then moving next door and being the toll keeper.
Yeah. And, unfortunately, I think this is a part of the practice. This is a part of regulatory defense and white collar practice where there's a lot of attorneys out there who come from the regulators. And I mean, you're talking about an extreme example, but it's not unusual, where they're the ones setting policy. And then they turn around very quickly afterward. They join private practice. And I mean, they're marketing themselves as, I wrote this policy.
Right.
Or I'm the guy to help you navigate it. Yeah. I know all those people over there. I'll get you out of trouble. I mean, that's the way they pitch it to their clients. And I think a lot of clients, they make the decision, well, I got to have that person. But, there's not a lot of incentive for defense attorneys to actually make things fair or better. Actually, probably the incentive runs the other way. It's better if it's more dangerous and more uncertain. And yeah, if I can go be a part of CFTC or FinCEN or something, and I can make things really, really rough for the industry, and then I can jump back out and I can defend everybody. And it's really unfortunate. And part of that is it's finances and it's making a buck. But I think that's a conversation we need to have, and I think that we need to have real thought about whether these policymakers should be turning around and representing the people that they were prosecuting, or, they're like people that are directly involved in their decision making. I mean, that's very concerning.
Yeah, no, absolutely. So, what we didn't talk about today, Caleb, we just ran a few high profile cases that the media draws upon. I had the ability, I spent 3.5 years in federal prison. I spent most of my time at maximum security prisons, and mostly transitory maximum security prisons, meaning that a lot of guys came through where I was. And so I had the ability to kind of be kind of a jailhouse lawyer, look a lot of their cases in real time, the decisions that they had to go through, whether or not to plea, to cooperate, what was the legal grounds on the case. And I learned quite a lot during the time that I did that. One of the guys that I helped was, I'm not going to mention his last name, but his name was Jared. I spent my very first days in prison with him, and he was sentenced to 12 years for selling a little crack. He was a 3-strike felon, and he was sentenced to 12 years in prison. pretty open shut. He pled guilty. He was sitting and debating. He was brave, courageous. They'd asked him to cooperate up, and he declined, and he did his time. I actually was able to help him get, through a new law, Amendment 782, I was able to help him get his sentence reduced from 12 years to under 10 years. And I was sentenced to 10 months in prison for helping him under association with the known felon, even though he was 500 miles away from me, serving time in Berlin, New Hampshire. So it just goes you the disparity. I have my own experience of tremendous disparity where guys like Robert Smith and Elon Musk and all these people will never do a day, or Timothy Leisner or whatever. And I could go to prison for 10 months in a maximum security prison, federal prison, for helping a guy with legal work. But that's the kind of disparities that we have. So we talked a little bit about the selective prosecution, the power of the prosecutors and regulators. It's been an ongoing debate for years. Everybody involved on both sides knows that it's disproportionate, but there doesn't seem to be any really active way to change it, Caleb. Is there anything realistically that you could tell the public that they could do, or what could be done to make it more transparent, to make it more even, to be more fair?
Well, I think the good news is just the fact that you and I are having this conversation is that's a positive step, because I think 10 years ago, 15 years ago, this wasn't part of the conversation. This wasn't, people didn't really think about what was happening. You didn't know about it. And I mean, we've identified a lot of the problems, right? A lot of the problems is the consolidation of power in the prosecution. And it is the kind of regulatory uncertainty that they can manipulate and they can push forward in a prosecution in these marginal areas. And, the sort of ray of sunshine is that we have this conversation and we can start identifying the problem. But I mean, no, I'll be honest with you. I mean, we're a long way off from a solution. And, I think there's a lot of people out there fighting. My organization, we fight every single day to try to push back at the edges. And, unfortunately, this is a long war that we're going to have. But I think it starts where people understand there's an issue. People start talking about the problems. And, the longer we go on and the more this becomes part of the conversation, I'm hopeful that we can actually have some real change. And, we're trying to hit it from all fronts. I work as a litigator. I go to the courts. I try to push back. I try to take these cases to trial. I want people to know about them. And, hopefully we score these little wins, we can stitch them together. But, it's a process. And I'd be thrilled if at the end of my career, I could see a marked change. And that's maybe as hopeful as I can be. But I'm happy that we're having this conversation because, this is one of those issues that nobody thinks about until it happens, until they find out they're being prosecuted or somebody they know is. They don't think it could ever happen. And then, wow, here I am. And now I understand. And so I don't want anybody to be in that situation.
Yeah, and that's so true, and that's been my experience, is that I think that people are focused on other things. They think they're compliant. I think I mentioned before, my friend Harvey Silverglate, he wrote a book years ago called 3 Felonies a Day, where the average person could potentially commit 3 felonies a day would not know about it. So we have over 4,000 federal laws. We have over 300 statutes that could lead to criminal felony convictions. He wrote a book with Sidney Powell, actually. Sidney Powell, who's the lawyer for General Flynn, actually. I know Sidney. And they wrote a book called The Conviction Machine. I asked, people they should go out there and because they rail against the power of the prosecutor. Sidney wrote a book called License to Lie that I've also read. So there are people that, and she's a former prosecutor and a high profile person. So it's not coming from you or I, it's coming from other people. But it's going to require, like you said, more debate, more conversation, and with the ability to enact change. We have to enact change and make it more fairer. So, but I want to thank you, Caleb, for taking the time today with me and in informing the public. You've been an invaluable resource for them and for me. I encourage you to continue to, fight the good fight. We need prosecutors. There are bad people out there. The people steal money. The people do bad things. We should have them focused on that and not make it a business and not encourage, other people to, steal money and help other people while other people are suffering. I mean, ideally, that's what we're striving for, right? To punish people who do kind of bad things. To make deterrents on people, to make sure that we all compete fairly and honestly and live moral and ethical lives, but make it fair, because that's really what we're told when we're growing up. So thank you, Caleb. Keep fighting the good fight. Thank you so much for taking the time. So that closes our segment today on selective prosecution. I hope you enjoyed it. It was informative, and as you can see, it is a topic that is very important to every citizen and businessman in the country, and something that needs to be addressed on an ongoing basis. I want to thank my guest, Caleb Kruckenberg, for his invaluable insights today. Thank you, Caleb. I hope you will join me in my next podcast next month. It will also be an important topic on qualified immunity. My guest will be Anya Bidwell from the Institute of Justice. Thank you again, and see you all next month.